Welcome back. Well, Mr. Mull, the legal practitioner, is here in the studios with us. Thank you for coming on today.
Thank you.
Well, first of all, looking at how they've gone about this in the House of Reps, they cite section 11.4. In fact, let me go ahead and read that 11.4 of the 1999 Constitution, which says, at any time when any House of Assembly of a state is unable to perform its functions by reason of the situation prevailing in that state, the National Assembly may make such laws for the peace, order, and good government of that state with respect to matters on which a House of Assembly may make laws as may appear to the National Assembly to be necessary or expedient until such time as the House or Assembly is able to resume its functions, and any such laws enacted by the National Assembly pursuant to this section shall have effect as if they were laws enacted by the House of Assembly of that state, provided that nothing in this section shall be construed as conferring on the National Assembly power to remove the governor or the deputy governor of the state from office. Initially, they were considering taking over before they decided to unanimously set up a committee to look into it. Now, let's look at some of these scenarios. Does this arise where the House of Assembly there are not able to perform their functions to warrant the National Assembly considering a takeover?
Thank you very much. You know, when there's the law is on one side,
yeah,
and the facts for the application of the law is equally on the other side. Now, the ultimate question is, the facts we have on ground, does it warrant the invocation of the provision of section 11.4? Now, you know, facts they say are sacred, so to speak. And it will all depend on which side of the divide you belong. Now, from a legal point of view, so to speak, if it is clear that the State House of Assembly is unable to perform its constitutional responsibility, by the provision of the Constitution, the National Assembly will take over. But the Constitution says National Assembly, not House of Representatives, not even Senate. Both parties must agree. Now, this is not the first time. I remember in 2016, in Kogi State, I think that was between February and March, the National Assembly took over the running of the House, of the State House of Assembly.
Don't forget Rivers too.
It happened in Rivers, but National Assembly did not take over then. It happened even in Ogun State. That was in 2009. Remember Benga Daniel and the Dimeji Lawal Imbroglu. Now, ultimately, I think the problem is that once there is friction between perhaps, quote and unquote, some very powerful persons within the state, it in most cases give rise to what we are experiencing now, meaning that those individuals appear to be stronger than the institution itself.
So is there a case in Edo State now, such that the National Assembly could
Well,
take
first thing first is that I will not be the one that will say so, but I'm aware, I want to think and I believe that there is a friction in Edo State. That is why we're experiencing or having what we are going through presently. Now, but the truth remains that if, as it stands, the State House of Assembly cannot function, the National Assembly will have no choice other than to invoke that provision. So that is simply the position of the law.
So the scenario is that they're trying to establish whether that situation persists or subsists at the moment.
Yes, that is a proper thing to do, to investigate. It's a proper thing to do on the part of this.
But there are two sides to this matter.
Okay.
You know, the people, the members who have not been sworn in, say, of course, they'll feel aggrieved naturally.
Okay.
But those who have been sworn in say, well, there was a proclamation by the governor. And after the proclamation, even though they went there, they say, yes, we had a quorum. There's a speaker, there's a deputy. There are some others who are supposed to be able to
Chamberlain, let's tell ourselves the truth. It is a 24-man house, not a 9-man house. It's a 24-man house, meaning that each of these men have people they are what? Representing.
Yeah, but does the law require all 24 to elect a speaker?
That's a presumption.
Does the quorum not give them that?
To elect a speaker, no. To elect a speaker, not all. Not all, sorry. To elect a speaker is just a simple majority. Simple majority, not one third, simple majority. That's what you need to elect a speaker.
And what number would
now,
that be?
Come again?
What number would that be?
No, it depends. It depends on those that are present, as it were. But when I say simple, no, you cannot orchestrate a situation where because you want to achieve a simple majority, you shut out others. Once the facts are clear that those other ones were shut out, that simple majority will, of course, will not suffice in the circumstance.
So essentially, you're saying that this situation shouldn't have occurred in the first place. But this is not the first time. You also remember.
That's what I'm saying. That look, it ought not to have occurred if we are people who stick to law and to rules. Because, you know, we are gradually developing into a country where might is right over law. You know what? Might is the one that makes sense over the issue of our law, that is the rule of law.
Now, in the event that this case, continues in this same trajectory, what do you see happening with the National Assembly making laws for the...
No, if it continues this way, the truth, like I said before, is that by virtue of the constitutional provision, you will not allow a state, because it's not like the federal. Because if this kind of thing is happening in the federal, that means it's total anarchy in the nation. That's a total breakdown of law and order. But because you have what you may call the almighty federal, that will be looking after the individual segments of the states, as the case may be. That is why once there's a friction in one particular state, they are now called upon to do what? To invoke or to use their powers to restore law and what? Order. So nothing stops them from doing same here if it happens that the state in question cannot function.
Let's go back to something you said earlier. You said the provision of the law says National Assembly.
Yes.
Not House of Reps.
Very well.
Not Senate.
Very well.
So you fault the composition of the House of Reps?
Not that I'm faulted. The thing is that what they are trying to do, they are not taking over now. They are saying that let us go and what? Investigate. So nothing stops them from carrying out that. So it is from the facts that they will get, they will not table before before the House and before the Senate, so that the Senate can now come to what you may call a reasonable conclusion to say, okay, I agree and I concur with your position, let us take over. Because remember, in Kogi State, for instance, it was a House that took the initiative. Then subsequently, the Senate took over. That was, I think, the House was on the 9th, the Senate was on the 18th of March, I guess. That's exactly what happened. Before they eventually took over the running of the State Assembly.
Okay. All right, let's get to Mr. Mull, and he's on the line this morning. He's a legal practitioner. He joins us from Abuja. Good morning, and thank you for joining us today. So, from your...
Thank you for having me.
Right. From your perspective, do you think the situation arises for the National Assembly or the House of Reps to set up an investigation to take over the functions of Edo State House of Assembly?
No, not at all. Not at all. Section 11, subsection 4 of 1999 Constitution provided that where a state house of assembly is unable to perform its functions by reason of situations prevailing in that state, the National Assembly may, the operative word there is may, make law for peace, order, and good governance. Now, the question is this: is Edo State House of Assembly unable to carry out its constitutional duties? The answer is no. Now, the operative word there is may and not shall. Now, let me take you back to what happened on the Edo State House of Assembly on the said date. The governor of Edo State made a proclamation for the inauguration of Edo State House of Assembly. And on the strength of such proclamation, the clerk of the House of Assembly did inaugurate the State House of Assembly, wherein a speaker and his deputy were elected by the members of the House present on the said date. Now, this places presumption of regularity in favor of the elected speaker and his deputy. Consequently, the agreed members elect, the options left for them is one, to approach the court of law for interpretation of the proceedings in the House, whether it conforms with constitutional procedure or best international parliamentary practices, or again, to make themselves available so that they will be sworn in by the speaker and then they can subsequently impeach the Speaker or his deputy if they have the votes needed to get majority. Similarly, strictly speaking, the members elect does not have right to complain. They do not have right to complain. Because it is outside the pieces of our law that a member who has not been sworn in will complain as to the activities taking place in the House. It's only when you make yourself available for inauguration and you are inaugurated as such. Now you cannot complain as to what transpired in the House. That has not happened. Now, if you look at Section 96 of 1999 Constitution, it never envisaged a situation where every member of the House must be present for there to be inauguration. No, it provided for one-third of all the members of the House. And one-third of all the members of the House is 8, because the State House of Assembly is comprised of 24 members. So they are 9. They met the constitutional requirement to sit on the same date. Now, what people are not questioning is, one, was there a proclamation by the governor? The answer is yes. Was there inauguration by the speaker, by the clerk of the House, who should have right to do such inauguration? The answer is also yes. Were members inaugurated? The answer is yes. Now, was Speaker and his deputy elected, duly elected by the members present? The answer is also yes. So, by some members who have not been sworn in, coming to National Assembly through their authorities to ask National Assembly to take over, the situation envisaged by Section 11 subsection 4 of the Constitution has not a reason for House to take over. Now, if you look at what happened in River State some time ago, when the House of Representatives did take over the work of River State House of Assembly, they did not do anything. They just took over. There was no legislation, there was no resolution, there was no oversight. So the intent of the famous of the Constitution was not for National Assembly to take over the duties of State House of Assembly at will, without playing the role, without playing the act, the constitutional act of the State House of Assembly. All
right, Mr. Nana, just hold on a minute. Let me bring it back here and take a look at some of the issues that you raised. First of all, he says that the law did not envisage that all the members will be present. He says Section 96 says it is 1/3 of all the members, not 2/3, not simple majority.
Now,
and which is 8.
Now, let me tell you, we are talking of inauguration because where he looked at now was when the House is duly constituted, so to speak, and probably there is need to take decisions or to make laws concerning whatever. But I'm concerned about at the initial stage when the House is about to be constituted. Will it be right to say, okay, because, you know, at that moment, you have just 9 persons as against the 24 that ought to sit on the day. And you now say, okay, you can go ahead. Although, one thing is certain, I agree that, yes, 1/3 can sit in the House. But first, we must also be very careful not to allow...
So if they have a quorum, they can proceed with proceedings of the House.
I'm coming. The issue of quorum, we have to be very careful here. There's a mischief which appears to be running in respect of this 1/3.
How?
And that could be dangerous in our polity. Now let me tell you. I'm aware from what he just narrated or he just stated that since 9 persons sat, so to speak, that 9 is correct to have done what they did.
Is it right or
wrong? And the other 14 can, you know, maybe by law, by what you have in the law.
So by law it is right.
I am saying that with the greatest...
By law it is right.
Let me tell you, the law itself, when it is to be interpreted, it will not be interpreted in a way that will create conflict. Because if you give, excuse me, if you give that interpretation... I'm coming, sir. That I must talk like a lawyer. If you give that interpretation as they have literally done so, then the state governors can decide to say, I want to work with only those that I know will be for me. And every other person...
That's a political interpretation.
No, don't say political. I'm telling you, you may say...
I'm coming.
Go ahead.
The 14 other members, fortunately, they've not been inaugurated though. The 14 others, they didn't make themselves available for inauguration. Why did that happen for them?
My brother, let me tell you something. That's why I said the facts are sacred. I am not in Edo State. I may not probably be abreast with the total fact or the entire fact. But you will ask yourself, why would it be that 14, they are 24-member house, but it's only 9 that was available on the day that proclamation was what? Made. It means that something must have happened. I don't know. You probably don't know.
No, but you said here that there is an ample degree of friction in the state between the governor and the former governor of the APC chairman.
I didn't mention anybody. If you remember, I said there could be powers that be. There's a friction. I did not mention anybody when I was talking.
Let me make it clearer for you.
Go ahead.
Will it suffice for you that the Oba of Benin, Oba Ewari II,
go ahead,
did meet with he met with President Muhammadu Buhari, and he expressed the fears that the two, the governor and the chairman of the APC, are at loggerheads in the state, and as a result, it is derailing governance in the state.
Very well.
Will that suffice for you that there is ample problem in Edo State and it's affecting the House of Assembly?
I'm happy I'm hearing that from you. That in itself will usually tell you that there's a friction. Now, and if that tells you that there's a friction,
so what's the next step for the National Assembly to take?
That is what I'm saying, that the first thing, because if the Oba of Benin actually went to meet Buhari, that's the president, the implication is that what he is trying to do is to...
Well, gentlemen, this is a point of law. Let me bring it back to law now, because that's a political one. Because number one is that Section 96(1). The quorum of a House of Assembly shall be 1/3 of all the members of the House.
I agree.
So if this is the case, as the law says, and if, according as Emmanuel Nene says, if he says it's 8. Now, don't forget, they're trying to determine, is the House able to transact business? Because that is the crux of why the House of Representatives of this committee.
Yes.
So if 8 or 9 of them are meeting and going about their responsibility, can they be said to have met the criteria to conduct business, and therefore the House of Reps have no grounds to take over or attempt to take over the Assembly?
Let me tell you, as far as I'm concerned, I am particularly inclined towards what will bring about stability, peace, and good governance. I'm coming, sir.
We all want that. We all want that, but we're looking at the law, what it says.
The law is not intended to create chaos.
But what does it say?
The law, excuse me,
have they fulfilled what
excuse me, sir. The law is intended to bring about peace. Now, if an action is taken in a manner which the law itself didn't contemplate, I repeat, did not what? Contemplate. For all intents and purposes, there is bound to be what you may call a second look.
If the law didn't contemplate that, why then is the provision of 11.4 in the Constitution?
That is what the 11.4 is meant to checkmate.
That means it contemplated it. If they're not able to transact business, then National Assembly comes in.
That's what I'm saying. I mean, I didn't say anything outside what I've said, that if it happens that they are unable to carry on their business, particularly in respect of the lawmaking and the oversight function and others, Section 11.4 will take over. But my learned colleague was of the view that, because he is speaking purely from the factual point of view, that look, from more indication, ABCD happened, and therefore it is correct. I am of the view that no, we must not read it that way. If we read it that way, we'll end up opening the floodgate for every other state to do what? Take suit. And what it means is that the governors, look, let me tell you, this law is not meant to be whipped. It's not meant to be used as a caricature.
But the law is still an ass.
I say it's not meant to be whipped. It may be an ass, but it's not meant to be whipped easily. But the point is that the law is one that is meant to regulate our conduct.
Okay. Sorry, there's Mr. Nene still on the line. Yeah. So before we lose him, Mr. Nene, you've heard the submissions of Mr. Meribe here, saying, look, if you read the law the way you have done, there just may be chaos, and everybody may want to take advantage, selecting their own people to form a quorum and transact business to the detriment of all the others who have been elected by the states to make laws for them.
Yeah, Kimberly, another thing the person I have to correct here is this. What guest in the studio is talking about, is it right for 9 members to have sat and did conduct the business of the House? The question here is not about whether they are right or wrong. The question here is about the constitutional provision, whether they met constitutional requirements as stipulated in Section 96 of the 1999 Constitution. If they met the constitutional requirements as stipulated in such section, then the conduct of the business on that day is constitutional. Now, what you also said about whether the people will manipulate constitutional provisions for their own good, that is why we have the court of law to interpret the actions or inactions of government institutions. If any person feels aggrieved, the person should approach the court for interpretation. And I said earlier, there are two options left for these aggrieved members. As it is now, they are members elect because they have not been inaugurated by the speaker. The issue is this. In law, do we have a speaker in Edo State House of Assembly and his deputy? The answer is yes. Now, let me fast forward it to what happened when Peter Obi was governor of Anambra State. 6 members of the House went to Grand Hotel in Asaba, conducted the business of the House there against all parliamentary procedures and norms. Peter Obi did not wail. He went to court and challenged the propriety of the actions of the Anambra State House of Assembly. And the court set it aside. Also, what happened when Joshua Judicial was governor of Plateau State? The same thing happened. And Joshua went to court and got got judgment in his favor. So, if anybody is talking about manipulating constitutional provision for his own sake, he's now relegating our court, a court of law, to the backdrop, because the court is always there to make pronouncement if there is infringement on the constitutional provisions. Now, going forward, the only option, I repeat, the only option left for those 14 members elect is to go back and be sworn in by the speaker. The National Assembly cannot do anything, because if you look at Section 14, it says prevailing situations in the state. Not even...
Nene, one moment, Mr. Nene. The law that you just quoted said, if the House is not able to perform its functions by reason of the situation prevailing in the state, don't you see this situation of 9 members of the House sitting in the place of 24 members of the House a prevailing situation enough?
No. The Constitution envisages a situation. The Constitution envisages a situation wherein 8 members will even sit and carry out the business of the House. So there's no constitutional anomaly.
Now, one more thing. Now, this also then indicates that, so from what you have said now, you're saying that the only option these guys have is to go to the court or go back to the House of Assembly. How do you expect them to perform in the House where they do not even feel like they were part of the whole setup of it in the first place? They are equal employees like everyone in the House.
Now, let me take you back to what happened in 2015. When the National Assembly was to be inaugurated in 2015, some APC members choose to go to International Conference Center for a briefing. Now, that didn't stop the National Assembly from getting convocated. What happened was that when they got wind of the fact that the National Assembly is being convocated, they hurriedly went to the National Assembly and were inaugurated by the Senate President then, not by the Speaker, because at that time, the clerk of the House had already inaugurated the House and sworn those members present in. So what we're saying is this: the House does not belong to the Speaker or his deputy. It belongs to all members validly elected. And the options left for them, I repeat, is to go back to the Speaker and got themselves inaugurated. That is when their right to complain will inure to them. Complaining as an outsider or as a member-elect is just a wishful thinking. It will not help them. It will not help anybody who wants to help them too.
Right, so we'll go to break and come back and conclude this. But the big question is, how are you an outsider when you've been elected by your state and constituency to make laws for them? We'll make sense out of it if we can when we come back in a moment. Stay with us. So we did ask, how is it that you're a member elected by your constituency to make laws and you can't? You say you're nowhere, in limbo, because you've not been sworn in. Now, these members, some of them have said, look, we have consistently screamed at the top of our voices, saying, look, we have made ourselves available, but we have not been sworn in. But as it stands, if they've not been sworn in or inaugurated, do they have any locus?
Now, let me tell you something. If for nothing, I was watching your program when one of the members of the House said how these 9 members were sworn in. the time it happened, meaning that it didn't even take place within the period when the business of the assembly will be conducted. Now, if all these things are facts, that I don't know whether they are real facts. When I say real facts, because I am not there, but those are things that they chew up. Fundamentally,
does that invalidate their swearing in or their inauguration? What
it will mean is that they have carried out an illegal act.
Well, even if it happened on the floor of the assembly.
If it is illegal, it's illegal. You cannot place.
What does the law say about the time that you can be sworn in?
About the time.
Did the law say when you can be sworn in?
There is a business. The question is that when does the business of the legislature begin and when does it end?
Who determines when?
No. By law, ordinarily, it's like even when you are working. You can't do it surreptitiously. You can't do it at night.
No.
You can't do it very early in the morning.
Time set.
Not even just the time. The question is, if it happened on the floor by midnight, is that illegal?
It's illegal.
What's going to happen today?
It's illegal.
What's now going to
happen? Why do it nocturnal? When of course it is a public affair. Why do it nocturnal? Why do it in the midnight?
What's going to happen?
It's illegal.
What's going to happen to the 14
members?
All
intents and purposes, we must tell ourselves.
What's the option for the 14 members now?
For the 14 members, well, ordinarily, as a lawyer, because we are after peace, peace, order, and good governance. They have no choice other than to approach the law court.
Yeah, so because if it's illegal, why haven't they gone? They can approach the court and say, this is not right.
You know why they've not gone? Let me tell you why they've not gone. With all due respect, I'm not unmindful. That's why I said we are treading on a dangerous path that is making people to lose confidence even in the judiciary. Because for all you care, when they go to court, they may not know when the matter will be attended to one.
They don't know when. That should be a blame to the judiciary.
That is the reason why I said that is part of what they are fear.
So judiciary is part of the problem now.
I didn't say so. I'm only saying that I am only talking from the angle of those 14 members who felt that the quickest way to deal with this matter is to approach the National Assembly. And that's why I mentioned earlier that we are moving towards a situation where we are saying might is what? Right. Over and above the rule of law.
Okay,
so not until even those who are lording it over us equally begin to adhere to the rule of law.
Okay, concluding thoughts
people
now.
Begin now to have confidence in our judiciary and then say, once it happens, and in fact, this nonsense will not even take place.
So, Mr. Anyane, if they were sworn in the dead of the night, whether or not it was on the floor of the house with the mace and all of those, he says it is illegal. So, are those grounds upon which the members who have not been sworn in, the members elect, can challenge this in court?
You see, Chamberlain, we forget so soon. When we had this subsidy of fever in Nigeria, National Assembly we called on Sunday. They sat on Sunday. And what transpired on Sunday was taken as the best parliamentary procedure. The issue of whether the House sat by 12 midnight or by 12 a.m. or by 2 a.m. is a question of fact, not law, which can only be determined by the court. Now, especially when what transpired did so on the floor of the House. Now, let me say this, and very clearly. Once the governor issued proclamation for convocation of State House of Assembly, he becomes functus official. He cannot issue another one until another election is conducted maybe 4 years in time. Now, having said that, my many colleagues keep having on sentiment. The quickest way is not the best way to it. The quickest way, according to him, is to approach the National Assembly against constitutional provision to go and take over. That is the quickest way. But that is not the best way for it. The best way for it is to approach the court or make themselves available to be sworn in. Now they cannot complain or muster to take majority and get the speaker and his deputy impeached. That has not happened. So let us not begin to say it is the way that cases are lying fallow in court. Now our court has also the issues to deal with, and this is part of it. If they choose to approach the court, let them do it timely, and that's what we call accelerated hearing. Because of the nature of this case, if they file a case today, you can approve accelerated affidavit showing the urgency of the matter. And I think my Lord Justice will give serious attention to the matter because of the urgency of the situation. But leaving what they're supposed to do and looking for cheap solution or easier solution.
We need to go. All right. We appreciate your thoughts this morning, Emmanuel Anene and Matthias Meribid, gentlemen, legal practitioners. Thank you both for coming on this morning. So here is what is coming up next.